I'm Emily Campbell from the Campbell firm, PLLC in New York City, and I'm here today to talk with you about Miranda warnings. So it's really important that people who are arrested stay silent. We all have seen on television and in movies the police explaining what your constitutional rights are through what we call Miranda warnings. You have the right to remain silent. Anything you say can and will be used against you in a court of law. The warnings go on to explain that you have a right to an attorney. If you cannot afford one, one will be appointed to you, and so on. These warnings come from a case that went up to the U.S. Supreme Court called Miranda. And every police department, every federal agency that is involved in law enforcement has to give these Miranda warnings to someone who is being arrested in order to advise them of their constitutional rights. So how is it that so many people manage not to follow these Miranda warnings or heed them? That they just start talking to the police, they start explaining themselves away, they blurt out information, or through a systematic interview or interrogation process, proceed to give the police all kinds of leads and information that would otherwise be very harmful to them in giving this information without the benefit of talking to an attorney. Well, it's because they don't stop talking. In order for you to have the ability to determine whether or not to talk to the police, you really need to talk to an attorney. You need to talk to that attorney before you talk to the police, because once you've given a statement, whether it's a written statement, a verbal statement, or you've just made some statements verbally that you don't even think are going to be incriminating to you, which will cause you problems in the prosecution of your case that will be used against you in the court. You really need to think about this, because if you start talking and you don't have the benefit of a lawyer, you don't know what you're getting yourself into. You're potentially getting yourself into much, much hotter water. Now, sometimes people believe that it's important to cooperate with the police, that people should say, oh, you know, this is my opportunity, I'm going to explain, I didn't do it, or it was an accident. Any number of things that someone might say that later could either be used against them, or if it's something like it was an accident, that incriminates you potentially because it suggests that you actually committed some type of an act that led to some kind of a problem, and then the court will evaluate whether or not, through a jury process or a bench trial, depending on the level of severity, whether or not you did that thing, and whether you will now have the burden of proving, potentially on an affirmative defense, that in fact it was an accident or that you didn't mean to do it. Because although the prosecutor has the burden of proof of intent, for example, if you assaulted someone and you have a self-defense claim, you have the burden on the affirmative defense of self-defense. The prosecutor has its burden, and then the burden would shift to you. So the best thing to do is to stay silent. If you make statements that you believe could help you, like, I'm innocent, I didn't do it, things of this nature, this information will never come in. So this is another reason why these self-serving statements are not going to be admitted, and so you're not helping yourself by stating this to the police or district attorney or any other federal or state investigator or law enforcement professional, because this type of statement will never be introduced in court on your behalf. Why? It's hearsay. Hearsay is the type of evidence that is a statement made out of court to prove the truth of that matter. So you're trying to prove that you're innocent. You say, hey, well, I told the police I was innocent. Well, unfortunately, that statement cannot then be introduced to your benefit. So the only kinds of statements that can be introduced in court are really the ones that are to your detriment that you've made. So you want to avoid making such statements. The statement against penal interest or the statement against your self-interest is the type of a statement that can be used against you in a court of law, and that's why those type of statements you have to be warned not to make. That's why they say, if you have, with the Miranda warnings, you have the right to remain silent. Anything you say can and will be used against you in a court of law, and that's because that is what happens. So when we talk about what the Miranda warnings, and you say to keep silent, well, what do you really need to do? You now need to really invoke your right to counsel. So how do you do that? So you invoke your right to counsel by stating unequivocally, that means definitively, without any hesitation, no hedging, nothing, You state, I want a lawyer, or I want an attorney. You need to be very clear. You don't want to say things that make it sound like it's wishy-washy, that you don't know what you're doing, that you don't know what you really want. Maybe you act like you want to talk to them, or you keep talking, which we'll talk about in a second, and what that potentially can do with your situation. But if you absolutely want to have an attorney, then you need to state so. And once you invoke your right to counsel, once you've declared that you want to have an attorney, the police are supposed to stop talking to you. Now, there are some nuances to this. Obviously, if you keep talking or you're unclear about your statement, for example, if you state something like, well, what if I want to talk to you and I want to talk to a lawyer? What if, can I talk to you for a little bit and then I can call my lawyer? That kind of thing. You want to avoid that. That is really not the direction that you want this to go. You want to invoke your right to counsel and then stop talking. This will hopefully prevent the police from continuing to question you or continuing to bait you into talking. Even if they continue to talk to you, you don't have to say anything, and you shouldn't say anything until you've had an opportunity to speak with your attorney, because police may be using certain types of tactics. Let's suppose before you ever say, I want a lawyer, they talk to you, they explain what you were arrested for, they're explaining what evidence they have. Maybe they have that evidence, maybe they don't. Maybe they say things like, hey, the other guy, if he cuts the deal first, he's going to get a better deal, this is your one chance, or things of that nature, or things that it will go better for you if you talk now. This may or may not be true, and most likely it is not true. The police, while they have certainly the right under case law to use certain tactics or strategies in obtaining evidence that they can use in a criminal prosecution, what we would refer to in the criminal defense world is this is trickery, and it is very, very scary for you because it may sound real, it may sound believable, but they are trained professionals. They know what they're doing, and they're going to use these tactics to get you to talk. And your best bet is not to talk. And once you stop talking, and you specifically invoke your right to counsel, they are supposed to stop talking to you. Exceptions to that, of course, is somehow you state you want counsel and then you keep talking about the incident. Now you've potentially waived your right to counsel. So that's one of the problems with continuing to engage in the dialogue of did you actually invoke your right, did you not invoke your right, and so forth. Now, if you don't understand your rights in English, for example, maybe your first language is Spanish or Chinese, you need to state need lawyer or need interpreter. Need some translation, need some kind of information, or make it very clear that you don't speak English, so that if in fact you don't speak English, so that you can get somebody to translate these rights into your native language, into your first language that you can understand. And once you have that, then you need to state in some fashion that is unequivocal that I want a lawyer. Again, I want an attorney, I want a lawyer, not some kind of a hedging. This is what you need to do. Now, we've had cases where, unfortunately, people have engaged in conversation with the police or the district attorney prior to engaging an attorney. This becomes very difficult to suppress. We make motions sometimes to suppress evidence to state that this evidence was obtained unlawfully or against the person's constitutional rights. You have a federal constitutional right against self-incrimination. State constitutions may also have this right. In general, you have a right not to incriminate yourself so that you do not have to give statements against your own interest that the police can use. Your best bet, again, to stay quiet. So when someone will continue to talk to the police and then want to try to suppress the statement later, very difficult. The question and the inquiry that the court takes at that point is this a voluntary confession? Is this a voluntarily made statement? And they'll look at certain factors. They'll look at how long the interrogation lasted, what were the circumstances, had the person eaten, were they tired, were they sick, were they under the influence of alcohol or drugs, different kinds of factors, and was there coercion or duress? Unless someone was holding a gun to your head or beating you up, chances are you're probably sitting in a room and you're just tired of talking, and the police might say even something that's trickery like, hey, you know what, if you just tell me what happened, you can go home. And obviously, if you confess to a very serious crime, you're not going to go home. So person may say that to you, the cop or the district attorney may say that to you, but it's simply not true. And in most instances, all you're going to do is really create a problem for lawyers that you do hire later, who will be defending you and will have this confession to deal with, to either explain it away or to try to get it suppressed, which may or may not be possible. So you really want to try to nip this issue in the bud from the very beginning. Now, what I would encourage everyone to do is, if you are arrested, you need to look at the situation, understand that you have constitutional rights, tell the police or the district attorney, I want an attorney, and then cease to talk. Then you can decide, with the help of your lawyer, after you've had that legal consultation, whether to cooperate or make a statement. Now, often, again, the district attorney or the police will tell you this is your one chance, that you won't get a better opportunity. This is the one time, and they want you to do that without the benefit of a lawyer. But you should not do that, because in general, most situations will not be waived. Will not be lost. Most opportunities will not be lost to resolve your case in a more favorable way, if in fact you have cooperating evidence or valuable evidence. In general, you want to talk to your attorney and determine whether or not what you have to say will help you in terms of the prosecution. Sometimes, again, what you think will help you really will not. We had a case, for example, a number of years ago, where it was prosecuted as a first-degree murder case. We came in, my firm, the Campbell firm, and our co-counsel came into this case after an hour and 40-minute monologue, essentially, had been given by the defendant in a very, very serious case. He had essentially confessed to what we would call felony murder. He had confessed to a robbery, and then claimed that the person who died during the course of that robbery had simply bumped his head when they were moving him. And the facts, which were shown through the autopsy and the coroner's testimony, from the medical examiner's perspective, that was not the case. There were multiple points of contact, and so a jury determined ultimately that this individual was guilty of first-degree murder. What the person thought they were doing was sort of, hopefully helping themselves by simply saying, hey, wait, it was an accident, maybe he bumped his head, but in doing so confessed to a robbery. And then when someone dies in the commission of a felony, then the district attorney can tack on to the complaint felony murder, which in New York is a second-degree murder charge and carries with it a significant punishment. Ultimately, based on the facts, the case was bumped up to a first-degree murder, and it was extremely difficult. We argued very, very, very strongly that this confession would be suppressed. But the person, as the court found, that the person was not unequivocally declaring their desire for an attorney. They used things like, what if I want to talk to you and I want to talk to a lawyer? When am I going to get a lawyer? Things of this nature. And what the police and the district attorney would simply do would be to repeat the Miranda warnings. Now, the Miranda warnings are kind of a state-roaded thing. They're not going to be explained any further. The district attorney is not going to explain to you your rights, and the district attorney does not represent you. Only your lawyer can represent you and explain to you what your rights are, in terms of the meaning, in terms of more depth of the meaning, and when it would be a good idea to talk and when would be a good idea to remain silent. So at the very beginning, certainly remaining silent is absolutely the best bet. Now, you may be presented with written warnings in addition to the verbal warnings. This is a very tricky situation because some of the warnings, the way they're written on the paper, give you this series of questions, and typically you're going to be answering yes. Like, you have the right to remain silent. Do you understand? Yes. You have the right to an attorney. Do you understand? If you cannot afford an attorney, one will be appointed to you. Do you understand? Yes, yes, yes. You're answering yes, yes, yes to all these questions. And then the next thing you know, then it says, and do you want to still speak to the police anyway? And you may, because you've answered yes to all the other questions, answer yes there. And now magically you've waived your rights. So this is a very tricky situation. Some of the questionnaires are less tricky, where it still is very clear you have a right to not talk or not, but these types of questionnaires have either not been challenged or have been challenged and upheld. And so you have to remember that even if you're answering yes that you understand, that does not mean that you turn around and then say, oh, and of course I now want to speak to the police. You want to stop, speak to your lawyer. Only with the help of your attorney can you evaluate whether to talk to the police, what to say, how it will help you, how it will not help you. For example, in the case that I was speaking about, where the person had given a confession, while there are certain circumstances, and we will talk in other episodes about false confessions, there are reasons that people should not confess, even under circumstances where they think they're going to be given a more lenient sentence or so forth, because there may be no provable evidence that they were at the scene, that they were involved in any way. I mean, sometimes there's no DNA evidence. Sometimes there's no cell phone records to show the person was there because their cell phone was not present. The GPS wasn't able to give it because the cell phone was off. Any number of circumstances. So it's super important to just to sit back, not feel pressured. Make a phone call to, if you're not getting a court-appointed attorney, indigent defendants will get court-appointed attorneys, people who cannot afford them. And at a bare minimum, you might be appointed an attorney to show up in an arraignment, and then you could substitute counsel later. But again, you know, getting an attorney involved, whether it's legal aid, 18B in New York. I personally am on the 18B panel for indigent defendants, and as part of our private representation of clients accused of crimes, the Campbell firm PLLC represents people in criminal matters, both white collar and other kinds of criminal matters, including obviously more serious cases like homicide. And we are encouraging people to remain silent. You have absolutely no reason to be talking to the police before talking to your attorney. Talk to your attorney first. Remember, you have the right to remain silent. It's your valuable constitutional right. You have the right to an attorney, another valuable constitutional right. And we at the Campbell firm encourage you to exercise those rights. Be safe, stay free, and remember, remain silent until you've spoken to your attorney. Thank you for listening.